Hello and welcome to Courts Today by Live Law. Let's get to today's top legal updates. Can Supreme Court fix timelines for President on bills? Reference filed under Article 143. Supreme Court to Vijay Shah. Ministers must speak responsibly. Hearing on Colonel Sofiya tomorrow. Supreme Court clears 500 crore Banke Bihari temple corridor. Approves use of temple deposits. Kancha Gachibowli deforestation. Pre-planned. Supreme Court warns Telangana with contempt. Supreme Court orders MCD to vacate Lodhi-era tomb office immediately. Supreme Court orders CBI probe in MP custodial death case. Asks about cover-up. In the Waqf Amendment case, Supreme Court to hear interim relief pleas on Tuesday. NEET-PG 2024. Supreme Court to hear plea on marks normalisation transparency on May 20th. I'm your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel because your support means the world to us. In a major constitutional development, President Draupadi Murmu has invoked Article 143 of the Constitution to refer 14 legal questions to the Supreme Court, seeking its opinion on the powers of the President and governors in dealing with bills passed by state legislatures. This comes after the Supreme Court's landmark April 8th judgment, which declared Tamil Nadu Governor R.N. Ravi's long delay in acting on 10 state bills as illegal and held that the bills were deemed to have been assented to. The President now questions whether courts can impose these timelines on the President or Governor when no such deadlines are given in the Constitution. Key queries include whether the Governor is bound by the State Cabinet's advice under Article 200, if the Governor and President's discretion is justiciable, whether Article 142 can override other provisions, and if the concept of deemed assent is constitutional. The reference also asks whether decisions under Article 200 and 201 can be reviewed before a bill becomes a law and whether such matters require a 5-judge bench under Article 145 Clause 3. The Supreme Court's opinion will significantly clarify center-state legislative relations. A major political and legal storm is unfolding after BJP Minister Vijay Shah called Colonel Sofiya Qureshi a sister of terrorists, triggering strong backlash. Colonel Qureshi, who led press briefings during the Indian Air Force's Operation Sindoor, became the face of India's military response after the Pahalgam terror attack. Shah's controversial comment, seen as communal and disrespectful, led the Madhya Pradesh High Court to take suo motu action and direct immediate FIR registration. The court called his remarks gutter language and dangerous, warning they insult the armed forces and fuel religious bias. Shah was booked under sections 152, 196, 1B and 197, 1C of the Bharatiya Nyaya Sanhita. He then approached the Supreme Court, where his lawyer argued the statement was misunderstood and he had publicly apologized. But CJI BR Gavai firmly reminded a person holding an office must speak with responsibility. The top court refused to stop the FIR and told Shah to first seek relief from the High Court. This case is now a high-stakes test of political speech, public accountability and communal sensitivity in India. The matter will now be heard by the Supreme Court tomorrow. In a major decision on May 15, the Supreme Court allowed the Uttar Pradesh government to use Sri Banke Bihari temple's funds to buy 5 acres of land around the temple for a 500 crore rupee corridor development project. The court, modifying an earlier Allahabad High Court order, stated that the land must be registered in the name of the temple deity. The bench of Justices Bela Trivedi and Satish Chandra Sharma said the move would help improve safety and infrastructure for the lakhs of devotees visiting the temple each year, especially after the 2022 Stampede incident. The court also emphasized the importance of proper temple management in the Braj region. It highlighted the urgent need for better roads, parking, toilets, dharamshalas, and public facilities in Mathura and Vrindavan, cities of great religious and historical importance. The judgment noted that while the Braj Planning and Development Board is active, true progress will require combined efforts from the government, temple trusts, and local communities. Key religious sites like the Yamuna River, Kashi Ghat, Kusum Sarovar were also flagged for attention and beautification to ensure a safe spiritual experience for pilgrims. The Supreme Court came down heavily on the Telangana government over the large-scale cutting of over 1,000 trees in the Kancha Gachibowli area, calling it a prima facie pre-planned act. The court warned state officials of contempt and possible imprisonment, questioning why deforestation began during a long weekend instead of a working day. The bench, led by CJI B.R. Gavai and Justice Augustine George Massey, expressed concern over the lack of environmental clearance and the absence of a restoration plan. The state claimed tree felling approvals took a year and said no further clearing was ongoing. However, the court was unconvinced, especially after the Central Empowered Committee's report noted 60% of the area was dense forest. The bench stressed that restoring the forest must be a priority. Meanwhile, whistleblower students from Hyderabad University face FIRs and jail. But the court said such issues were beyond the current case's scope and directed them to approach the High Court. The matter arose after Telangana Industrial Infrastructure Corporation sought to convert forest land for IT development. The court will hear the case next on July 23rd. The Supreme Court has directed the Municipal Corporation of Delhi or the MCD to immediately vacate its unauthorized office built on land surrounding the 500-year-old Lodhi-era monument, Sheikh Ali Gumti, in the Defence Colony. The order follows a January 21st decision in which the Defence Colony Welfare Association, which had illegally occupied the monument for over 60 years, was told to hand over the Gumti to the Land and Development Office. DCWA has been fined Rs 40 lakhs for the encroachment. Despite an earlier April 8th deadline, the MCD had not vacated the site by May 14th. The court has now directed possession to be handed over to the L&DO by May 15th, after which it will go to the Department of Archaeology for restoration. The court also ordered removal of a tilted wall blocking the view of the monument. A CBI inquiry revealed DCWA had made unauthorized changes, including installing meters and building structures. The heritage site's restoration will be guided by expert Swapna Little. The matter was brought by local resident Rajiv Suri, underlining the importance of preserving historical monuments. The next hearing is on May 16th. The Supreme Court on May 15th transferred the investigation into the alleged custodial torture and death of a 25-year-old Deva Pardhi to the Central Bureau of Investigation. A bench of Justices Vikram Nath and Sandeep Mehta criticized the Madhya Pradesh government for not arresting the police officers accused of the incident, calling it an attempt to shield them. Deva was arrested with his uncle Gangaram in a theft case, and his mother alleges that police tortured and killed him. The police claim he died of a heart attack, but the post-mortem report showed multiple injuries. The court slammed the state's handling, questioning why officers found complicit were only shifted to line duty and not even arrested after 10 months. The court also expressed concern about the safety of Gangaram, who is the sole eyewitness of this incident, currently in custody, and suggested he may be safer in jail to avoid threats to his life. Directions were given for considering his bail and providing him protection. The court called the state's response ridiculous and inhumane and said custodial violence continues unchecked, with offenders often roaming free. On May 15th, the Supreme Court posted the matter challenging the Waqf Amendment Act 2025 for hearing on interim relief on Tuesday. A bench led by CJI B.R. Gavai made it clear that the challenge will be limited only to the 2025 amendment and not to the original Waqf Act of 1995. The court said that it will not allow anyone to bring in challenges to the 1995 Act under the current proceedings. The petitioners' counsels, including senior advocates Kapil Sibbal and Rajiv Dhawan, raised concerns over the 2025 Act, particularly the omission of the Waqf by user provision and inclusion of non-Muslim members in the Waqf boards. Solicitor General Tushar Mehta submitted that the government has filed a detailed reply on key issues and requested time. The court reiterated that drastic changes should be avoided while the matter is being heard. Intervention pleas have also been filed by several BJP-led states supporting the act. The petitions challenge multiple provisions, including the exclusion of historical Waqf claims and dilution of Waqf rules. The court has renamed the matter as in the matter of challenge to Waqf Amendment Act to avoid polarized impression. The Supreme Court will hear on May 20th a batch of petitions raising concerns about the NEET-PG 2024 exam, especially regarding transparency and the process of mark normalization. The petitions highlight issues like the last-minute change in exam format, lack of access to question papers, response sheets and answer keys, and discrepancies in scorecards. The petitioners argue that students were not given enough tools to verify their performance, and the newly introduced system for mark normalization has created unfairness by dividing candidates into two sessions after altering rankings. Although the National Board of Examinations informed the court that NEET-PG 2024 admissions are complete and sessions have started, petitioners stressed that the matter relates to broader issues affecting future exams. The NBE defended the mark normalization method and said the change was necessary due to limited high difficulty questions. The court noted the broader implications and agreed to tag the case with another similar matter listed for May 20th. Earlier, the court had questioned the decision to change the exam pattern just 3 days before the exam, calling it unusual and stressful for students.